again that has been said in this court over a period of time.
No, it's fine. I'll control that. Thank you, Mr. Late. Yes. Before we start with the replies, there was an indication. I think Mr. Sibara and Mr. Pina had not yet decided as to whether they will need to reply or not. If I may find out. Mr. Sibara, are you there? And Mr. Makani? Are they there, or have they not joined yet? Yes, Mr. Pina?
May it please the court, my lady. If called upon, I will have a short response in replication, my lady.
Okay, that's fine. You'll be afforded that opportunity. Mr. Sibara and Mr. Makani, are they not there? Please just tell them they shouldn't disrupt the proceedings. We'll just continue with those who would like to submit, make further submissions in reply. I'll start with, I don't know, Mr. Hasim started, Ms. Hasim, Mr. Hasim.
Earlier on in the oral argument before the inquest. So he's already had a chance to respond. What my role is to reply to what emerged during the argument that came after me. If we were to keep going back and forth, then we'll never end. So in my view, there isn't a purpose of a reply in any event in relation to Mr. Pitlela.
Yeah, but if he wants to say something, he can go in before you, because as I've already indicated, this is only to deal with only one NGO, while you have to deal with the rest of the mental health care users. Yeah.
I have no objection, of course, if Mr. Pitlela wishes to say something, but we can't keep going back and forth.
I understand. Thank you.
Thanks.
Yes. Mr. Sibara, are you there before we start? I'm going to request that if they are not there, him and Mr. Makani, or they're still battling, we're going to proceed. They will indicate.
We are here.
Yes, I just want to know.
Earlier on. Yes, you called me. I couldn't switch on my camera and my speaker, but now at least I can switch on my speaker.
Respond. Yes, I just want to find out, are you going to make submissions?
At this stage, none, unless if when advocate Hasim say something that we might want to respond to it, because yesterday she asked to be the last.
Okay.
Unless if something.
I understand. Yeah, while I'm giving whoever wants to reply an opportunity, side should not be lost that to the fact that I also afforded all of you an opportunity to reply, and I've got your supplementary heads that were filed. So it's not necessary for some of you to reply, but if you want to, you're not going to have too much time. That time is going to be limited. So either you're going to be addressing the court for about 15 to 30 minutes and not more than that. I hope I'm clear. Mr. Pinar, you may proceed then. Mr. Makani, if you can just lower your hand. Thank you. Yes, Mr. Pinar.
May it please the court, my lady. My lady, my submissions are restricted and do not entail a long exposition of the evidence that has been presented to your ladyship, with which your ladyship is well conversant. At the end of the day, my lady, when your ladyship evaluates the evidence and hands down a ruling, which is your ladyship is obliged to do in terms of section 16(2) of the Inquest Act 58 of 1959 as amended. It's my respectful submission that subsections A, B, and C of section 16(2) will not be presenting a serious obstacle for your ladyship in reaching or handing down a ruling. Having listened to all the evidence, it's clear the problem emanates with the application of section 16(2) subsection D. But I would submit, my lady, that should your ladyship not be able to hand down a ruling as envisaged in section 16(2) subsection D, it would be proper for your ladyship to hand down a decision in terms of section 16(3), my lady.
Thank you. That is all.
Lady,
Yes.
the only further issue I want to refer to, my lady, is the fact the National Strategic Plan 2013-2020 envisaged at least a 5-year time frame within which to perform the removal of mental health care users or transfers from an institution to other institutions. But this time frame of 5 years as envisaged to reduce bed occupancy, for example, at Life Esidimeni institutions, was then compressed after the date of termination being the end of September 2016 to the 30th of March or 31st of March 2016. And thereafter, a further extension was granted of 3 months until the end of June, 30 June 2016. So
yes, that evidence is on record, Mr. Pineda.
That's correct,
yes.
my lady. But this is of importance because it indicates, my lady, notwithstanding the requests by Mr. Mosanogi regarding the fears and concerns that existed, he requested an extension of at least a year or 12 months.
Yes.
Which was not granted. And now a project, the strategic plan, which envisaged a 5-year period, was actually compressed.
Correct.
Within a period of an additional 3 months to be performed, my lady.
Yes, we hear that.
Yes. My lady, so that is a factor which should be considered in evaluating the evidence, my lady, as well as the fact that the Gauteng Department of Health acted for all practical purposes as a party in loco parentis regarding mental health care users. And as such, the requirement was, my lady, I would submit with respect that the Gauteng Department of Health had to act like a diligens pater familias. But in this case, because we know, and that's common cause, mental health care users are the most frail and vulnerable section or portions of society in our communities. I would express that, submit respectfully that it's not just the requirement of the diligens pater familias, but the diligentissimus pater familias. The utmost care had to be carried out, my lady. And this combines with the fact that removals took place, transfers took place without an informed consent from medical health care users. When their families wanted to intervene, they were dismissed and it was not considered. And these are facts, my lady, I submit should be not lost sight of when your ladyship is evaluating the evidence presented. And then furthermore, my lady, the fact must also be kept in mind, I submit respectfully, that subsequent to the 30th of June 2016, when the marathon project had been completed, if I can call it that, there was a directive to Dr. Salabana, remove all mental health care users back to hospitals or qualified institutions, which conduct, my lady, I submit, is an admission that the project as it had been implemented had failed, had not reached its goals. I would respectfully submit that justifies the conclusion or the inference, my lady. Why was this done? Whether it was on an instruction from the National Minister of Health or an instruction directly from Dr. Salabana, the head of the department, it was to curtail further deaths from occurring, my lady. And that is a factor that should be considered. And then lastly, my lady, I would respectfully submit that no conclusion or ruling can be handed down by your ladyship implicating Ms. Hannah Jacobus, be it prima facie or be it in your ladyship's respectful opinion that she had acted in a manner constituting or representing a conduct or an omission on her part that was with a direct nexus to the demise of any single mental health care user. May it please the court, my lady, I have no further submissions in reply to your ladyship.
Thank you. Mr. Profi, are you there?
I'm here, my lady, ready to proceed. Unless Ms. Hassim wants to address the court, because I see her camera is on.
Ms. Hassim, I think this should be in error. Ms. Hassim, I think something is not right there.
My apologies, my lady. I didn't turn it on until now. I'll try to correct that.
Okay, thank you. Mr. Profi?
As the court pleases, my lady, this is then the bulk or the primary basis for my reply is based on the submissions made by Mr. van Bergen in respect of the users. So where I'm going to begin is when he had started his submissions, the difficulty I have is that Mr. van Bergen made this submission that based Dr. Manamela should have foreseen the adverse because she was warned, and given her common human experience, position, education, she should have foreseen it. So my submission is then that that very same premise of common human experience, position, and education, similarly, I don't see why Dr. Makacho could not have foreseen the adverse impact. And then he made the submission that he warned the department in 2007, and that in respect of the marathon project, he had warned the department and particularly Dr. Manamela. Now, my submission is that I find that that doesn't work in his favor, because if someone is warning the department at the pains which Mr. van Bergen wished to express to the court, then the foreseeability in respect of those adverse findings falls at his feet as well, because then if he's warning the department about these consequences, but then when his part to be played in the marathon project comes, having that knowledge, he then turns a blind eye in respect of the consequences of his conduct. Then I'm turning to Mr. van Bergen's submissions that my heads of argument are speculative, leap in logic, etc., etc. My difficulty with that submission is later on, he then points out and speculates to the court and says, my lady, I'm speculating, and then makes a bunch of allegations. So my submission that those submissions where he based it on speculation, the medical records were in a different file, maybe this could have happened, maybe that could have happened, is of no assistance to this court. And that quantifies his criticism towards me, that my heads of argument are referenced with evidence, whereas his is referenced to his own statement of it being speculative. So those submissions are not supported by evidence. But I'm going to then turn to the relevance of Section 16 of the Mental Health Care Act. Mr. van Bergen's submission was that only the discharge report is what was required to be given to the receiving facilities. Now, the importance of that section is that it says the purpose of the discharge report is for care, treatment, and rehabilitative services to indicate in that report. So, my lady, the crux of the submission I'm going to make, I'm not going to repeat it, but mere showcase the analogy that is supported by paragraph 18.3 of my heads of argument.
18.3, yes.
Correct, my lady. It is the analogy in respect of Ms. Mokhoja's evidence that the discharge by Dr. Sabia read as prescription reports, so it only gave the indication of the medication that the user was on and not the relevant evidence is at paragraph 18.3 of my heads of argument. The only analysis I wish to present to the court is the consequence thereto. With Mr. van Bergen just saying we gave them what we should, even if we look at, if the court is with him, that is what they were only supposed to give. In respect of docket 109, that is where in my heads of argument and from the evidence the comparison was made, and Dr. Mkachu confirmed that that is a lacking discharge report because it only reflects medication. Then if we go to docket 113.
Just a second.
What figure, what treatment this user was on, or what the diagnosis was, which again, those submissions are made in my heads of argument in respect of you cannot expect a receiving facility to puzzle together the treatment plan and the physical examination of the doctor, because the Mental Health Care Act is clear on what is meant, how a user is supposed to be admitted, and the relevant documents and the purposes for those documents. So if we now look at docket 113, so we don't have a discharge report. So we don't have, that means no physical report, no care, no treatment, no future care plan. The NGO would not know that. Now, even if we were then expected to look at the periodic report, my submission is then that is the relevance to the outdated periodic reports, because you don't have a discharge form, or you have a discharge form that reads as a prescription. You then try look to the periodic report and to see what the last year, because they're mandated to do the review annually. If you look to the periodic report, for many users, those were extremely outdated. So the NGOs couldn't then even rely on how the user was cared for or where his health stands in the last year. And that is where the submission is based, that it interrupted continuous care, because no matter which avenue the NGOs tried, there was no way on these records to determine the care and treatment and rehabilitative services for the users. Now, I'm not going to repeat it, my lady, but it's in docket 94. The premise is the same. We have a periodic, which is 2009. Similarly, we move to docket 87. Similarly, we have a discharge by Dr. Sibia, no prescription, 2008 periodic report. Such inadequate records clearly hampered the NGO's ability to care. And that is based on fact, which is from the evidence, which was further confirmed by Dr. McCutcheon. So it's not speculation as Mr. Van Bergen submitted. Now, when I say that it's further confirmed by Dr. McCutcheon's evidence, I just want to refer the court to the relevant evidence substantiating my submissions. If we have reference to page 47903.
47903.
Correct, my lady. It's the transcript, the relevant back.
Just a second. Yes.
My lady, the relevant background begins at line 10, but my emphasis is line 17, in which the doctor confirms that the relevant documents to be transferred, to be given to the transferring facility is a discharge summary, periodic report, and the prescription for the user. And he confirms that the physical examination would have been noted in the discharge summary.
Where? Okay. All right, I can see that.
From line 17, my lady.
Yes, I'm there.
So I'm merely just giving the court the page references which substantiate when I submit that his evidence confirms my submissions. These are the evidence I'm referring to. The next relevant portion of his evidence is 4790. If I want to complete that submission. So Mr. Van Bergen's own witness tells this court that in his view as Life Esidimeni, the receiving facility in order for continuous care to continue would be those three. Mr. Van Bergen then argues that it's only a discharge summary which is required, and that doesn't speak to the evidence of his own witness.
Okay, thank you.
I move to page 47906. Where he confirms that the oldest periodic report ought to have been 2015, and then
This is now line.
sorry, I didn't note the line in my.
Well, I've got it 1, 2, 3. Line 3, I think, from the top. That's when it's you now. Then he says that would be correct. Just check there.
Correct. Yes, ma'am. So the oldest periodic reports, and then he confirms that that is correct. So it's lines 3 to 6.
Yes, anything else? I'm looking at my time here. You are left with 3 minutes unless you have other things to say.
I do, my lady. I don't think I've reached my 30-minute mark yet.
Continue. It's you are at, I think it's the first 15 minutes. It's about to expire in 2 minutes. Continue.
The next page is 47908, line 20. There he states that a reasonable clinician would not have accepted a client without proper documentation. My submission is then that similarly, a reasonable facility such as Life Esidimeni should not have provided such improper and lacking documentation, and further should not have refused when the records were requested.
Continue.
The next page is 47910, line 12.
47910. Okay.
Line 12. This evidence speaks to Mr. Van Bergen's submissions that the reasons why the discharge reports was so brief was because the users were stable. Now, my submission there too is, how were the NGO supposed to know that? If the one document that they were supposed to get is then completed briefly, how were they to know that the users was stable. And the result of that is then they would have no information to work from. That is the very purpose of the Mental Health Care Act and why the provisions of Section 16 and 30 are there. May I go to the next page, my lady?
I'm listening, continue.
47922, it's in respect of Rebecca. Here, the submissions remain that what Mr. Van Bergen did.
47922.
It's the evidence in respect of Rebecca. So there, Dr. Makacho confirms that she had a running diagnosis of CCF. So that is not in line with the submissions made by Mr. Van Bergen. The evidence speaks that the doctor confirms that she had a running diagnosis of CCF. Then she arrives with no medication. Then I submit the submissions made in my heads of argument then stand. He confirms that what happens afterwards is beyond his control and the receiving NGO should have instantly addressed it. My submission is that it was in his control because Dr. Sekukune went to Life Esidimeni to request the records. Now, the rider there too, my lady, is that Dr. Sekukune was an executive at Life Esidimeni, so she fully understands the records and expectations that is on Life Esidimeni to a receiving facility. So when she goes there, she goes with the knowledge of what Life Esidimeni is supposed to do, but she gets no assistance. It's the evidence that Mr. Lahau also went to request the records, and then Dr. Manamela also requested the medical records. So the other difficulty I have with Mr. Van Bergen's submission is that he then says that there was a prior arrangement with Dr. Makacho and Dr. Manamela where entire medical files were requested and provided. So here, sufficient records is being requested and they're not provided, which has a fatal consequence. So why Mr. Kacho could provide full, entire medical records previously, but when he's asked by 3 individuals this time, he cannot do so. Then, my lady, I'm moving on to the submissions in respect of Ms. The submissions made by Mr. Van Bergen would be you take one line out of the evidence and then form a submission out. During his cross-examination that the evidence found at page 46256, line 9. The court emphasizes that this evidence is crucial because she confirms that some of the documents were not complete in the discharge form and the discharge forms were not complete and they didn't get periodic reports. So Mr. Van Bergen's submissions leaves out very crucial information, which even the court had emphasized was crucial. So his submissions are incorrect. I then want to turn to 46257 and 4. There she confirms that some had periodic reports and some did not have, and some were old. My emphasis is line 8, where she confirms we did not get anything about the physical reports of the patients, and that evidence is relevant in disputing the submissions made by Mr. Van Bergen. Now, where I'm going to conclude this point in his evidence as succinctly as I can is there was multiple objections towards the end of her evidence. It concludes at page 46282. I had objected, Mr. Priscilla had objected, and Mr. Priscilla's objections find relevance here again, because what Mr. van Bergen did in the evidence and what he did in his submissions is he would extract one correctly completed here, if my lady has regard to this one, it's complete. So the submissions that it's incomplete are speculation. And Mr. objected to that, to say you cannot just take one. We have to look at the users individually to find the one specific to the evidence the witness is giving. Once the evidence leader objected, I objected, the court concluded that she was but a nurse and not a psychiatrist, so the further cross-examination was not allowed because it wouldn't be of assistance to the court. So my submission is based on the court's ruling at the end of that those arguments and those objections. He then makes submissions against my lady's ruling that uses the evidence to make the very submissions that he attempted to make, but for the court's ruling. So similarly, those submissions then shouldn't stand in light of my lady's ruling. Then, my lady, I just want a point of clarity, is that the argument or the submissions made presents that full entire medical records were requested, and that is unfair to life Esidimeni. Nowhere in my heads of argument or in the evidence was it asked for full files. The contention was always the issues with the discharge report and that the information that was meant to be provided in respect of the 3 records as confirmed by Dr. Mkacho, that those were inadequate. That is the records which I make reference to when I say records were not provided. It's not the entire medical file. Then the point I wish to make is that Mr. van Bergen's submissions that he made, if one has regard to them in totality, they stand as justification or defenses to what should have been presented to a criminal trial and finds no place here. So to present the defenses to this court, to then say, the point I'm making is that he could make those submissions based on evidence which is credible. If we look at the evidence of Ms. Mkhosinane, Ms. Mkhoja, Dr. Supuna, and Dr. Manamela. That evidence is before this court, and he could argue on that evidence. This court has to then find, is there credible evidence to sustain a criminal trial? It is not the correct platform for Mr. van Bergen to then say, well, here's my defense, here's my answer to it, my lady. Find beyond a reasonable doubt here already that there's no need for us to go to a criminal trial. I submit that premise is incorrect. The test is whether there is evidence, and there is evidence because he argued on it. The 2 last points I wish to make, my lady, is he tried to disregard Ms. Mkhoja's evidence in his submissions because she didn't care for the users on a day-to-day basis. That was canvassed in his cross-examination with Ms. Mkhoja. That evidence is found at page 46529, line 5. Where she confirms she's a psychiatric nurse, she went up file, she had insight, she confirms what they told. She tells the court why she has the insight and why she knows what is missing from the records. He again addresses that aspect. It's emphasized at page 46531. 46531, line 20.
Yes.
So the evidence of Ms. Mkhoja and Ms. Mkhosinane, they're complementary. And the basis for why she could comment was clearly canvassed by Mr. van Bergen with her. Then, my lady, my closing remark is I had objected and the court ruled that he should argue them. There is then the inquest. And lastly, my lady, I'm going to be intentional about when we came back from the T adjournment, I had referred specific users. I'd given the court references to specific users for referral of Dr. And there was a reason for that, because if one looks at my submission based on time of arrival, time of death, and reason for the cause of death, many of the users would then fall through. The reason being, I can't make the argument that the time frame that it interrupted care, but the user could have been there for a year and a half. So it's that reason why many of the users were not referred. Yet Mr. Van Bergen chose to make submissions in respect of users which I didn't state should be referred. So I'm not going to reply to those submissions because they aren't part and parcel of the users who I had said referral is justified there too. So I'm going to ignore those submissions because there'd be no need for me.
Yes, Ms.
When he was under examination by me, as your ladyship pleases.
Thank you. Yes, over to you, Mr. Pichel.
If the court pleases. My lady, if I can just clarify one thing. The reason I requested an opportunity to reply was in response to what your ladyship had mentioned, that anybody who wants to respond to the issues that were raised by Mr. Pitlela in his address, especially the issues of ownership and so on. Now, I understood that to mean that once everybody has spoken in response to what I've said, then I'll get an opportunity to also say my few words. It's
Okay,
not
the issue was dealt with yesterday, and perhaps you can just respond if you want to, and then we clear this matter. I don't want us to be like going forth and back. I think the issue was dealt with yesterday. Those who wanted to respond in regard to, do you want Ms. Hasim to deal with it? What if she doesn't want to? Remember, Ms. Bandle-Lenda dealt with the issue in her in her argument.
Well, if it doesn't have any reason to reply, because
okay, that's fine. Should she raise that? Should she raise that? You will have that opportunity. But I thought it was dealt with yesterday. Thank you.
That's your leadership.
Because from what I heard from your submissions, I don't know if there is anything more that you want to add, because you have referred to the authorities that you rely upon. All right. Then I'm remaining with, before I go to, okay, Ms. Hasim, you may proceed.
May it please the court, my lady. I just to say that I will say something very briefly about the question of ownership, etc. But I don't think it's something that really requires a reply. But we'll deal with it when I get there.
All right, the court will determine that. Okay, thank you.
My lady, if I may begin by just providing you with an outline of my reply. Which not foreseeable, that the officials were not warned of death. 3, the argument that arose that there's just an absence of evidence in the inquest that permits the court to make a finding. 4, the value of the judgment by Justice Moseneke in the arbitration. And then just 1 or 2 specific responses to submissions that were made by Mr. Sibara and Mr. Pitlela. And finally, my lady, I'll address the complaint that was raised, I think, by Mr. Pitlela at the outset of his submissions regarding a press statement by my client.
Oh, okay. Yes.
So, my lady, you've heard quite a lot from everyone who's made submissions to you about the test to be applied under the Inquest Act. And everyone is in agreement.
Just before you proceed, I'm sorry to interject. My question, in fact, related to a further submissions by Mr. Van Bergen, who included the civil test, remember? And whether I should also consider UK jurisdiction, something like that, yes. Jurisprudence, yes.
My lady, my submission to you is to stick to the language of the test as it is expressed in the Goniwe judgment. And if you stick to the language says that the test, rather, as articulated, is whether you're of the opinion that there's evidence, and these words are important, which may, the line may, and then it says if accepted, and then it says could prove. And that's important because it doesn't say if there's evidence which will probably be held to be credible. It doesn't say whether there's evidence that will be held to be credible. It doesn't say that the test is whether the court is of the opinion that the evidence will be accepted. It's if accepted. And it doesn't say that the evidence should be of a standard where that it would prove that the death was brought about by certain acts or omissions. It says could prove that the death was brought about by certain acts or omissions. So, my lady, I think that it's probably most prudent for the court to just stick to the language of the courts that have expressed their views on the test prior to this, our courts. So I think, while it may be interesting to read the UK judgment, there's no need for us to import anything into our law as regards the test. We dealt with it in huge detail, but I would, sorry, my lady, there's just some, my lady, what I wish to say is that I would like to refer the court specifically to paragraphs 28, 29, and, well, paragraph 28 to 31 of that judgment. I think it's useful because it clearly sets out what is required by legal causation and the consideration of legal causation. The court, the Constitutional Court there spoke about the traditional tests: adequate cause, novus actus interveniens, and so on, reasonable foreseeability, the criteria. And it said that each of the tests is not without its problems. And what follows is that it must be treated as being subsidiary to the considerations of public policy, fairness, and justice. And so, how you determine, for example, remoteness will mean not just applying those traditional factors, but ascertaining what those implications are in the context of considerations of public policy infused with the norms of the Constitution. That's what the Constitutional Court said. So this court is free to express an opinion on legal causation on the facts of this particular case with reference to the norms and values contained in the Constitution, but it is a legal test rather than factual that the court will be considering. And ultimately, it will be for a criminal court to come to a final conclusion on whether legal causation is established or not, with reference to the test that, as described by the Constitutional Court. So, my lady, this is just to offer you some guidance as to how to consider what you are faced with in this inquest. That's all I have to say about the test. With regard to the deaths being not reasonably foreseeable, there have been several submissions by several of my colleagues in the court that, with the benefit of hindsight, it's only with the benefit of hindsight that we can say that these deaths were or that we can try to claim that the deaths were foreseeable, but it couldn't be at the time when the events were taking place that the deaths were foreseeable. And they said that someone, I can't remember now, but it's in either in the submissions, written or oral, that Professor Robertson and Dr. Talatala themselves didn't say that death would occur. The important thing to remember in relation to what Professor Robertson and Dr. Talatala said is, one, when they said it and why they said it, or why they didn't say, rather, that death would occur. The first is that they were warning, and the warnings that they were making at the time were in relation to existing NGOs. The NGOs that we are dealing with in this inquest, and particularly in the case of the 10 deceased that we focused on, are new NGOs. They didn't exist at the time of the termination of the contract with Life Esidimeni, and they didn't even exist at the beginning of 2016. So they were not aware that there would be new NGOs that would be considered. MEC and Dr. Manamela knew this because of their involvement, as we have shown in our heads of argument. Professor Robertson also testified that the reason she didn't warn about death specifically is because she was anticipating that the people who would be moved were people with mental illnesses only, not with comorbidities and not with physical disabilities, particularly disabilities of the serious nature of this cohort of mental health care users. So that's my response to, well, even Dr. Talatala and Professor Robertson didn't say it. This is really the point. They didn't need to warn of the deaths. It's not dependent on whether Dr. Talatala or Professor Robertson warned of death. The warnings are in the record. We referred to it in our oral argument in chief, and I need not go there. What I wish to say is, to the extent that this was missed by my colleagues, is firstly, Dr. Mkachwa did warn of the possibility of death. He did so with reference to a previous occasion in which the Gauteng department moved mental health care users from a facility. And it resulted in, it was children who were moved, and it resulted in death of some of those children and others who were referred back to hospital with malnutrition and dehydration. So, and he also says in the arbitration, he said that he reminded the department about that incident. And that was in the arbitration. In the inquest, perhaps I should just give you the reference to both, my lady. In the arbitration record, it's the arbitration record. It's on case lines 23470.
23470.
Yes.
Yes.
And in the inquest, it's case lines 38094.
38094.
That's correct, my lady. That's the point where he says that he had warned Dr. Manamela and Dr. Salabano about potential fatalities. To Dr. Mkachwa, the letter from concerned organizations, SADAG and the South African Mental Health Federation, that was dated 2 June 2016, in our heads of argument, that letter reported deaths. It reported the negative outcomes and the risk of negative outcomes, including death. You'll recall, my lady, that this is the letter to which Dr. Salabano responded, in which he said this is a painful chapter. Now, the point about that is that that was 2 June 2016. It was before most of the deaths occurred. So when one is contemplating who knew what and when, it's important to look at the spectrum, the whole continuum of this project. Not just at the time of the decision to terminate the contract with Life Esidimeni, but all the acts and missions that took place afterwards. And in essence, it was a refusal to hear any of this and to continue and press ahead nonetheless. Now, how is it possible that these individuals and organizations were able to foresee the risk of death, but not those who run the province, who run the health services in the province? If anything, the MEC for Health and the head of the Mental Health Directorate should be most familiar with the state of mental health services in the province. So how is it that others were able to warn of this and families were able to express their concerns, but not those who were in charge? And how is it that all these other people were demanding that the whole endeavor, but not the people responsible for their care? The people who were responsible for their care, in whose custody the mental health care users were, they were not demanding that there should be a halt. Now, so it was, neither did the former MEC or Dr. Manamela, or for that matter, Dr. Salabano. None of them made that demand. The response to those who were making the demands and were clamoring, the response was to do nothing. Nothing. The plan went ahead. They certainly reconciled themselves to the outcome. Just in relation to the legal standard, here I'm indebted to my learned friend, Mr. van Bergen, for his reference to the port of the case of Van Schalkwyk.
Which one?
Van Schalkwyk.
Oh, yes, okay.
And paragraph 15 in particular, which quotes Appellate Judge Brandt in S versus Humphreys about the test for subjective foresight. And I need not repeat it, but I submit that the court would draw benefit from that paragraph. So what we have is objections by those who some of us have implicated, or have said that there's evidence, sufficient evidence to bear out that that the finding can be made under the Inquest Act against these individuals. So the objection in relation to the legal representatives for Ms. Mahlangu, my learned friend, Mr. Hodes, referred to the analogy of a motor car, hoping that this would bring a breath of fresh air into the hearings. And I will say that it was entertaining listening to the analogy of servicing a motor car. But obviously, this case is not about servicing of a motor car. It's not about changing mechanics. It's about moving mental health care users to places that were not fit for them to be placed in. And users who Ms. Mahlangu knew were on the high end of the care spectrum. And I say that because there's evidence on the record, because it was in those warnings. The use of the words high end of the care spectrum was in the letters and all of the statements. It's in the record. So knowing all of that, so it's not just that the analogy doesn't work because it's not about a motor car and servicing a motor car. It's because it doesn't work at several levels. The first is, it's not that the former MEC was told that there were costs and you need to move service provider because of costs. We've dealt with the costs and the issue of costs, and that it was clear that it wasn't, while there were cost issues, it wasn't about, and the cost containment was required, it wasn't about containing costs of essential health services. So that could never be the basis for doing what happened and what happened next. And of course, we know that it was recommended to the former MEC that she could have bought the Life Esidimeni facility. And in that way, all of the mental health care users would have remained stable with the staff, and it would have been under the control, direct control of the department, and no longer having to pay Life Esidimeni, but that choice was not accepted. Secondly, she was told about the consequences. We've set that out again in our heads of argument in detail. She was also told about it, as we know, by Mr. Masunohi. And that letter, my lady, of the 12th February 2016, Mr. Masunohi's letter, is worth reading quite closely, because the letter, there was a letter and there was an email, and the letter was attached to the email, and both are worth reading closely, because what Mr. Masunohi said is that these facilities are not adequate for such specialized patients. He used the word such specialized patients, and he said that the clinicians support the request that was being made, and that the impact of the decision will result in relapse. So these are the kind of warnings that were put to Ms. Mahlangu. Her argument that she relied on the knowledge of and the information provided to her by experts, both inside and outside the department, is just not borne out by the record. The record shows the opposite, that her decisions were not based on what the experts in and out of the department were telling her. Her conduct was contrary to what they were saying. Why would Mr. Masunohi say to her that this is a problem and we need more time, much more time, or perhaps buy Life Esidimeni? And if they are in charge of the project, then why did the MEC not just agree with and trust their better knowledge, people who are involved on the ground? Third, we know that she was involved throughout. We set that out in our heads, and in my oral argument in chief, I did make reference to the records of the meetings that Ms. Mahlangu chaired. And those meetings that she chaired were throughout the implementation. It wasn't that Ms. Mahlangu made a decision to terminate the contract and thereafter left it to the others. That's not what happened. And we know also that Dr. Celebano testified in the arbitration that there were regular meetings with the MEC. In fact, in the arbitration, he said he was not in charge. And my lady, that record reference is page 27625. And he said that the MEC knew about the marathon project. He further said that the meetings were very tense, the meetings with the MEC. Now, Mr. Hodes said that, well, she was responsive to what the project team was advising, and that when she was asked to extend the implementation period to the end of June, she did. The point is, she was not asked to extend it to the end of June. She was asked for up to a year extension and other things. It was her decision to say, no, I'm only permitting an extension to the end of June. And that had a very serious impact on what unfolded. And, you know, the evidence leaders in their heads of argument say that in a perfect world, there would be a phased discharge. There would be a slower process so that one can assess whether each individual mental health care user is adjusting to the place to which they're being discharged. And if they're not, and if there's a risk of relapse, to bring them back to the facility where they were stable. But it's not a perfect world. That's not the standard of a perfect world. That's a standard that was being applied in Gauteng, in South Africa, in 2015, prior to this project. It's the standard that was applied prior to this travesty. Why there was a need to depart from it, we are not told. So this thing of time frame is very important. The decision by the MEC to extend it by only 3 months is very important. It's possibly the most crucial aspect of any implementation plan is time frame. Yet the MEC dictated the time frame, not the people who were implementing. And instead of, as I said, acceding to the request, she refused. So it was because of that short time frame that the new NGOs had to be found, who had not taken care of mental health care users before, and who did not have sufficient funds of their own, and they could not meet the basic needs of the mental health care users. There was not even time to do a proper audit or even to sign a service level agreement with these new NGOs. We're not saying, my lady, as Mr. Hoda suggested, that we are saying that we must hold the MEC responsible. It's not for us to say. The standard is the standard in the Inquest Act. The court here is not going to be making findings of guilt. Mr. Hoda has also referred to the fact that our arguments are mutually contradictory because we set out evidence in relation to Ms. Mahlangu, Dr. Manamela, and Ms. Ngube. Well, the first thing I wish to say, my lady, is that it's not our task, and it's not our role, and it's not our intention to gun for any specific person in this inquest, but it's to prevent the evidence of where the responsibility most likely lies. There are policy considerations, for example, to be made regarding the issuing of licenses by Dr. Manamela and whether that was sufficient to interrupt a chain of causation between Ms. Mahlangu and what happened. But that's a decision to be made. It's a policy decision to be made. Mm-hmm. The Inquest Act explicitly recognizes that there may be more than one person's one person or more than one person who against whom the inquest court may make findings. Mm. Now, That's not a question of having a mutually destructive. It's just a question of saying, well, here's the evidence. Maybe it applies to all three. Maybe all three are responsible. Maybe only two, maybe only one. But whatever the case is, that was the purpose of setting out the evidence in relation to all three. And in any event, my lady, you're not constrained by our submissions. You're not limited to our submissions. This is the court's inquiry. The court will make its decision based on the evidence that's before it. So we're not limited to the fact that we, Section 27, made submissions in relation to three people. This court may find that there's other people who are implicated. The fact that we didn't say anything about Dr. Salabano doesn't mean that he's not implicated in some way. So that much, my lady, is in relation to the argument that the deaths were not reasonably foreseeable. Then the absence of evidence argument, that was made, several of my colleagues said this inquest is characterized by an absence of evidence. And we seriously disagree with that opinion. There's sufficient evidence before this court. There could be more evidence to come. The other assumption is that, well, this is the height of evidence, that there could be no further evidence to come. Well, I'm not sure what of giving evidence. So, and you know, my lady, we do know that there is, for example, Ms. Mube spoke about material that she had given to the SIU, some of which were photographs, which were then provided to this court. But there were also clinical records that she says were provided to the SIU. We haven't seen all of those clinical records. So there may be something further. So my point simply is making a broad, sweeping statement, well, there's nothing more, is not in the interest of justice and is not borne out by anything. So then I'll turn to the topic of the value of the arbitration judgment, my lady. Now, let me start first with saying that it was a judgment that was made after hearing oral evidence from many witnesses on oath and affidavits and documentary evidence. I've previously, I think at the outset of the inquest, referred the court to the case of the Institute for Accountability in Southern Africa versus the Public Protector.
That one I know, it's in your heads, no?
It is in our heads, my lady. But I can repeat it, the citation, if it would help. It's 2020.
Yes.
Volume 5.
Yes.
SA Law Reports, page 179. The judgment of this division, and it's at paragraph 31 that we wish to draw the court's attention to, where the court describes what a judge's duty is, and that the findings and opinions that are addressed in the judgment is based on procedures, including law of evidence, that are designed to ensure that the opinions of the judge is based on the correct information. So, of course, the arbitration findings are not binding on this court. But that doesn't mean they're of no value to this court or that they should be ignored by this court. Now, Mr. Martin referred to there are some things that are, for example, the Ombuds report. Part of the Ombuds report was set aside, and so to the extent that the Ombuds report featured in the arbitration and all the times afterwards, it must be borne in mind that there are other factors, for example, the findings of the ad hoc tribunal.
Mm.
But first of all, that ad hoc tribunal did not overrule everything.
Yes.
The Ombuds report. That tribunal made finding in relation to Takalani and Moseko. It said the findings were that there was no conclusive evidence of mental health care users dying under unlawful circumstances in those NGOs, that they did have professional staff, and that they didn't have evidence of, this sort of evidence to support the findings of cause of death. But that is because that evidence was not before the tribunal. There was no evidence before the tribunal of Deborah Petla and her post-mortem, and of her mother, and of all of the circumstances that were happening at Takalani at the time. Those circumstances, my lady, are all in the record. It was dealt with by the arbitration, where, for example, Dr. Salabano acknowledged that the evidence, there was a report on typhoid at Takalani in July 2016. And the report included findings of insufficient space, pungent foul smell in the dining hall, a dirty kitchen, etc. Now, Dr. Salabano had conceded in the arbitration that that was evidence that the facility was not suitable in March 2016. We referred to this records. It's paragraphs 403 and 404 of our heads of argument, and all of the references to the record are there, including the reference to Mr. Mosonogi and what he had to say about those particular facilities. So that evidence was before the arbitration. So the findings by Justice Moseneke were informed by more information than was before the tribunal. And that's important for the court to note that. So while the court is not bound, as I said, it cannot be dismissed or ignored as findings that were made that are of no use to the court. And if the court were to say, well, based on the evidence in the inquest, you have a different view, well, then the court will say why the court takes a different view to Justice Moseneke. But there would have to be a reason for why there's a different view. Secondly, there was an issue that was raised about this, the Ombud, the thing that was overturned, the Ombud finding that that Dr. Manamela was not authorized to issue licenses. My lady, I don't think this is something that should detain this court. It's not really a question, ultimately, of whether Dr. Manamela had delegated authority to sign the licenses. That's not the question. We accept, and the court should just accept that she had the authority to sign the licenses. But that doesn't mean that the person issuing licenses can hand them out without satisfying herself that the people she's giving the licenses to meet the requirements of the license. It's not sufficient to say, but I was told by my officials that everything is fine. That's not sufficient. The person issuing a license has to satisfy themselves. I mean, any license that one applies for, or a passport for that matter, you've got to provide a whole stack of information. You provide health records, you provide photograph, you provide information regarding your finances, depending on what passport you're applying for. There's a ream of information that needs to be supplied. When you hand that over to the official who receives the information. It then gets handed up to someone else who issues a passport. But they don't issue the passport and they say, oh, because Miss So-and-so at Teller whatever told me that all the requirements are met. No, it's all there in the folder. And these are licenses that affect people's lives. So it was her duty to satisfy herself that those facilities could provide the services they were required to. So Justice Moseneke's findings are based on what was before him. He wasn't on a frolic. And that was why he found differently to the ad hoc tribunal in certain respects. There was also evidence before Justice Moseneke from quite a number of experts in that arbitration. So, my lady, the end of that submission is to say that there is a great deal of value to be had in the judgment of Justice Moseneke. My lady, there was a submission made by Mr. Profi that the submissions on behalf of the families in Section 27 were these sweeping statements of starvation and neglect that he said have no place in the inquest. And I mean, it sounds like nice rhetoric by Mr. Profi, but the reality is that there isn't any statement that we make to this inquest that is not supported by reference to the record. Every statement. It's why our heads of argument are that long. Almost every sentence has a footnote with a reference to the record. Those tendencies that we focus on, all of them died as a result of starvation or neglect. Why did we say that? Well, it's set out in our heads of argument, and it's borne out by the record. And as far as the issue of Deborah Petler and the argument that, well, there were actually sufficient staff, well, the evidence shows differently. The evidence is that she wasn't supervised, because if she had been supervised closely, she wouldn't have eaten all of that plastic and brown paper and whatever else. The evidence of the pathologist was that it would have been a slow death, but at no point did anybody intervene. And that's because, can only be, because nobody saw. She was left unsupervised in a room. Then in relation to the specific submissions of Mr. Sibara, yes, Mr. Sibara referred to the email of a Ms. Orrit, an email of 2 January 2016. And my lady, our submission is that that really doesn't take us too far. There's not much in that email. And in any event, none of the new NGOs existed by then at that point. The second email he referred to is of 2nd October 2016.
Just a second. Yes, continue.
My lady, actually, in that 2nd January 2016 Ms. Orrit email, there were supposed to be annexures, but there weren't annexures. But if you have a look at the email, where 16 refers to a mental health budget spreadsheet.
This is now the email of October 2016.
To October 2016, my lady.
Yes.
I think it was from a person named Paul Trina. Now, the email refers to a mental health budget spreadsheet, but we have no idea what that is in that spreadsheet, and we have no idea what that has to do with Dr. Manamela satisfying herself that NGOs met the requirements for a license. We have no idea. Regarding Precious Angels, Mr. Sabara referred to a report, and I think Mr. Pihlela as well, signed by Ms. Rochelle Gordon. And it was that report, my lady, where all the boxes were ticked as having satisfied those requirements in that checklist, the inspection report. But there are a couple of things to say about this. First, Mr. Sabara didn't deal with the evidence of Ms. Gordon that she was asked to go to the Johannesburg office, that's to the office of the Mental Health Directorate, and made to fill in those forms from her memory. And that she testified that it was because Dr. Manamela wanted them in black and white. Those were her words. She also said that she told Dr. Manamela that audits were not done. On 28 July, there were visits by Ms. Zanello and Dr. Lenkwane and Hannah Jacobus and Mr. Tabane. And that report detailed just how bad things were at Precious Angels, both those reports. So I don't think there really can be any reasonable dispute about the conditions at Precious Angels. And then finally, when Mr. Sabara says, well, you know, Dr. Manamela was responsive. And when she was told about the NGOs running out of linen and food and short of medication, that she stepped in and she responded, and she did that in the interests of users. But the point is, they should never have been sent to a place where they would not get medication, would not get blankets, wouldn't get linen, wouldn't get food. That's the point. So it really doesn't assist Dr. Manamela to say, well, she then stepped in when she was told that she needs medication. Then, my lady, in relation to Mr. Pihlela, and this is the last part of my reply, just to respond to one or two things there. Well, the first is this issue about whether she's an owner and if liability can be imputed to an owner of an NPO or
before you touch that, there was a submission that he made that why single out Precious Angels, and coupled with that, he also mentioned that why do you disregard the things, the challenges that the NGOs had at the time when he listed them? If you can deal with that, and then you can close with
yes, my lady. in fact, we don't disregard that, because when we deal with the evidence of Dr. Manamela, that evidence that evidence shows the lack of support to the NGOs. So we don't deny that. The difference with Precious Angels, my lady, number one is the number of deaths that took place there.
Just hold it there. Just a second. Yes.
Number two, the fact that Ms. Ncube didn't only take patients once, but she returned for more patients. And so there was a point at which we submit Ms. Ncube could have said no, and she didn't. Third, 5 of the deceased that we focus on demised at Precious Angels. That's part of the reason why we focus on Precious Angels. And finally, my lady, it was Ms. Ncube who was at the scene of collecting the patients, taking patients to the clinics when they were very ill or not at times. But it was only Ms. Ncube who had the responsibility of doing that. It was Ms. Ncube who hired the staff who were not capable of caring for mental health care users. And of course, that's also borne out by the record. It was Ms. Ncube who took out personal loans to cover costs. It was Ms. Ncube who borrowed houses from her uncles. So that's the reason why we make the submissions we do with regard to Ms. Ncube.
Okay.
It was a personal conduct that we referred to. Then Mr. Pitlela said that Advocate Raja Badlander had made an unfounded claim that that there were no nasal feeding tubes at Precious Angels, but then goes on to say, but Mr. Makhoba was fed through a nasal feeding tube. Well, that's totally incorrect. And it's in the evidence. Advocate Raja Badlander did not say that Mr. Makhoba was fed through a nasal feeding tube. She said, on the basis of the evidence of Mr. Nofile, that Mr. Makhoba was fed with a syringe with food that was softened by hand, by the hand of Sister Julia. And that is confirmed in Sister Julia's affidavit. So that submission by Advocate Raja Badlander is based on the record. It was a syringe. Secondly, Mr. Pitlela took issue with the submission that there was partially digested food in the esophagus of Mr. Virginia Makpela. Just one last thing, sorry, my lady, before I go to Virginia Makpela, is Mr. Makhoba's death. Sister Julia speaks about, I'm sorry, I'm just trying to remember. It's page 46019. I've just forgotten now. It was testimony. 46019.
Okay.
That the evidence, I think it was Mr. Nofile who said that they had to hold Mr. Makhoba's hands so that they could force his mouth open and that Sister Julia could feed him in a syringe. So that's from the evidence. With regard to Virginia Makpela and the partially digested food in her throat, or in her esophagus, again, Mr. Pitlela took issue with this. Again, like others suggesting these are some made-up facts. that we've put to the court. But in fact, that comes from the evidence of Dr. Onoya. It was Dr. Onoya who talked about undigested food being in Ms. Machpela's esophagus. And it was Dr. Onoya who said that the indication was that it was pushed down there. Those were the doctor's words. Finally, Mr. Pichlela said he seemed to suggest that this court should not have regard to affidavits. We stronger. Those are statements on oath, and they are what they are, and the court can take them into account. Mr. Nofile and Dr. Onoya testified before the inquest, and so there was ample opportunity for Ms. Ncube to cross-examine those witnesses. And there can be no question of the fact that there's affidavits, or if I understood Mr. Pitlela's evidence correctly, that this offends Ms. Ncube's right to a fair trial, because one, this is not a criminal trial, and two, there was an opportunity to cross-examine Mr. Nofile and Dr. Onoya.
But with regard to, because his statement relates to affidavits where the witnesses were not called, I think further to that.
Yes. So, my lady,
that is why he's saying those statements were not challenged. Therefore, they infringe his client's right. That's how I understood him.
Ms. Ncube did testify.
Referring to the affidavits of those witnesses who didn't testify.
Yes. Well,
remember, we also have, yes.
She could have dealt with it when she testified. She could have provided her own evidence about what happened, and that was what she did. She came and she testified before the inquest, and she gave her version.
Okay.
But my lady, there's a more important point, which is that, again, this is not a criminal trial. Sister Julia, or whoever else, provided affidavits to the inquest but did not come and testify, will testify in a trial, and her rights will be protected at a trial.
Anything else? Don't forget the issue of, is it the issue of ownership?
Yeah, my lady, that issue of ownership is, I'm not sure that it's something that, again, should detain this court, because where we refer to Ms. Ncube, we do so with reference to her own personal conduct. Doesn't matter how she was described. And in a criminal trial, well, whatever needs to be corrected with regard to how she is described, whether she was a center manager, whether she was an owner or not, will be dealt with there. It's really a red herring. The question is, what did she do and not do?
Okay.
So, my lady, those are our submissions in reply. May I have, I know I'm going to deal with the media statement. Let me deal with that first. The only thing left is the media statement. Yeah. So I'm aware of this. I requested this media statement from Section 27, and I've been provided with the statement. I've read it. It's a press release that was issued prior to the oral argument commencing in this court, and it sets out what was to come and what the requirements of an inquest act are, what the arguments of Section 27 would be, and the denials, what the evidence of the persons on whom we implicate, what their argument is. My lady, issuing a press statement in the context of an inquest that's being live streamed and where Ms. Ncube has been participating throughout, this is an entirely public process, and it has been from the beginning. I don't see why this particular occasion is something to be, subject of a complaint. There's also nothing stopping Section 27 or the families talking about what's happening in the inquest or informing the public about the fact that the inquest is going to recommence with these arguments. So, Milady, I don't think that there's any substance to the complaint.
But he was saying, Ms. Nube was saying, people are saying she's going to go to jail and all those. I don't know. I think that's what he said. Yeah.
Milady, I don't know. I don't know. We don't know what. I don't know what happened. I don't know what those facts are. I don't know specifically what Ms. Nube is referring to. What I do know is that people have been saying that since the arbitration. So it's been an issue. It happens when it comes to hearings such as this. And criminal trials. It happens in criminal trials. It's a public hearing. It's a public process. It's unfortunate if anyone were to be targeted, in an unreasonable fashion as having caused death. But and certainly that's not what we would want to promote. But it's not something that can be controlled either by the court.
Okay. Thank you.
May I have just 1 minute to confer with my colleagues?
Okay, please.
If I've left anything out. Thank you, Milady.
All right.
Yes. Milady, I've just been asked to emphasize again that 1/3 of the patients at Precious Angels, 1/3 of those who were transferred died there. And just to remind the court that the court is not required to make a finding against only one person. Other than that,
there was an issue that the court is not required to make findings in terms of the Mental Health Care Act. I think
I am in agreement with those submissions.
Yes. Okay. All right.
And I'm aware, as Mr. Martin pointed out, that we had ourselves referred to it in the opening statement, but the submission is correct, that is not for this court to make findings.
Correct. Yes.
That's not appropriate for an inquest.
All right.
Thank you, my lady.
Thank you.
As it please the court.
I take it that, Mr. Sibara, I take it that this is the end of the supplementary arguments.
My lady, it's Advocate Makani. There's 2 issues that we want to address.
I can't see you, Mr. Makani.
And also to fix my laptop, if you can just be given until 1:15 to fix the laptop and also to reply to 2 issues.
Yeah. I see Mr. Pitlela, his hand was up before you, Mr. Pinar, and then you will follow.
The court, my lady.
Okay. Mr. Pitlela?
My lady would like an opportunity to respond to some of the things that were raised.
Do you still have a right to reply, Mr. Pitlela?
I believe so, my lady, because with reference to my client in particular, my lady...
you speak to yourself as you speak. You are not speaking to the court because that's why we can't hear you.
My lady.
Yes.
Maybe let me put it this way. Everybody had the opportunity. We read each other's sets of argument and everybody replied thereto. Now, the Learned Senior Counsel has been given an opportunity to respond further and not limit her response to the issues that I had raised that might be considered as new, the one about ownership and so on. She went further than that. So now I believe that I should also be given an opportunity to clarify certain things that arose from her address.
Is it clarification? Or, just a second. Are you clarifying or is that a reply so that we can understand what
I'm
you...
replying, my lady, because I'm not proposing a back and forth kind of thing. There's very few things that I need to be able to state to this court that are going, and also to this court to certain aspects of the record, so that this court can then draw a comparison between the two.
All right. I saw there was a hand from Mr. Pinar and Ms. Hasim. Ms. Hasim, you can go first because it looks like you want to respond to what Mr. Pichela has just submitted. Yes.
Yes, my lady. My lady, the design of the schedule was very deliberate. The schedule of the order of submissions. And it was done so in that way because in order to allow a response to submissions by those who were implicating others. So because we were implicating people, it was important that we went first so that there could be an answer by those, including Mr. Pechlela. So that was the purpose of the order of the submissions that we presented to the court. So that's the first thing I wish to say, my lady. And Mr. Pechlela testified just yesterday, in which he did answer our submissions. And my issues in reply that I raised today all have to do with what he said yesterday. The ownership issue was in response to the court's question about ownership.
Correct, yes.
And then these other specifics about the feeding and the nasogastro feeding tubes and such things were raised by Mr. Pechlela yesterday, and those were the only things that I replied to. So I would, my submission would be that it's just an abuse to keep coming back. But you know, it's in this court's hands. But I wanted to bring to this court's attention that there was a method behind the schedule.
Okay. Thank you. Yeah. Mr. van Bergen?
Yes, my lady.
Did you raise your hand?
I did not, my lady.
I saw it was
no.
up. Okay.
My apologies if it was raised. Is it still up, my lady, or not? It doesn't show up.
It does no longer show now.
No, thank you, my lady.
Yes. Yes, Mr. Pechlela?
My lady, there's a few things that I want to mention, and they are relevant to what has been said. I'm not trying to advance a further argument. And it will be very difficult for this court to say, yeah, you've had your chance and so on. The purpose of how this thing was arranged, that was never discussed. We were given a list with slots to say this is what we are proposing the order should be. There was never a discussion about the implications of the order of the things being in that manner. For now to be saying, yeah.
Where does this take us, Mr. Pechlela? Procedurally, isn't it? My question is, do you still have a right to reply? Forget about the schedule, because this has been agreed upon, and it was for the purpose of assisting the court in terms of who should go first, right? So,
my lady,
in respect of the order of the day, but my question is, do you still have a right to reply? If you request that, then the court can check if it will allow you to do that. But procedurally, are you allowed to be replying after every reply?
My lady, I'll posit that I have the right to reply, the same right that was given to Advocate van Bergen SC when Mr. Profi finished addressing.
Yes, he asked, now, he only, just a second. That is why I asked you a question. Is it a reply or is it a clarification? He wanted to correct certain statements that were made by Mr. Profi, and the court allowed him on that basis, right?
I also want to correct certain statements.
Oh, now it's no longer a reply, you are changing.
No. I said I'm going to refer the court to certain portions of the record in response to what has been raised here, so that evidence will speak for itself. I'm merely giving the court reference numbers to pages,
Okay.
and then I'm going to clarify one aspect.
All right. Can we, it's now 6 minutes to 12. Can we resume at 12:15 so that we give Mr. Pitlela a chance, and then Mr. Sibara or Mr. Makani, on behalf of Miss Manamela, then will be the last to address the court. Oh, I also forgot Mr. Pina. Can we take a short adjournment? Remember, we didn't take the tea adjournment. Let's resume at 12:15, and then I'll first hear Mr. Pina.
May it please the court, my lady.
As the court pleases, my lady.
Yes,
Your
Your
Ladyship
Ladyship
pleases.
pleases.
recalling the matter?
No,
Like
there's no
Esidimeni-
there's no need to do that. It's fine. We are proceeding.
Okay,
I'm
thank you.
sorry. Yes. I said I was going to hear Mr. Pinar first, followed by Mr. Pitlela,
Yes,
then
yes.
Mr. Makani. Yes, Mr. Pinar?
May it please the court, my lady, may I request an indulgence to just present a closing remark I failed to make to your ladyship this morning when I addressed your ladyship initially, my lady. It's going to be very short.
Hey. All right, please. Be short.
Thank you, my lady. I'm indebted to your ladyship for the indulgence. My lady, I referred to the extension of a 3-month period which was granted by the MEC. In conclusion, it was quite clear, I submit with respect, that an extension of 3 months did not require Solomonic wisdom nor prophetic insight to realize that an extension of 3 months would not be sufficient to finalize and complete the marathon project and as such address the fears and concerns whereby death is included of being addressed. What it did require, my lady, nonetheless, was chameleonic temerity in proceeding with the marathon project. And failure to comply therewith, my lady, resulted in a hasty and chaotic process being followed to the detriment of the mental health care users involved. That's the concluding remark I failed to present to your ladyship. I'm indebted to your ladyship, and that concludes my address to your ladyship.
Thank you. Mr. Pitlela?
Thank you, my lady, for this opportunity. My lady, there's two things, there's two references there's two places I want to refer the Honorable Court to. Page 54057. 54057.
Yes.
And 54059. This is the evidence in chief of Robertson.
Yes.
Where she confirms that she signed off on 3 NGOs.
Come again, where she confirms that?
She signed off. She was called to a meeting and she was made to sign a document where she signed off on 3 NGOs, confirming that they are ready to take patients, and later regretted that decision.
Okay.
And the question I want to pose to this court, my lady, is...
just a second. I see Ms. Hasim.
My lady, I really don't want to curtail people and what they're saying, but there has to be some rules regarding when you can, have a further opportunity to address the court. What Mr. Pitlela just said has nothing to do with what I said in my reply. Well, I didn't speak about Professor Robertson and her role in NGOs or any of that. I mean, that's already been on the record, all of that stuff. I just don't understand what the point of it is. And I've just felt it, I needed to register that, my lady.
Okay, thank you. Mr. Pitlela?
My lady, it's the first time I hear an objection to the closing address. But nonetheless, Your Ladyship, the role that we are all here to perform is to assist this court. And if, like with Advocate Pinar just now, he says that I've neglected to refer the court to one aspect, and now I'm referring to it. So I'm saying to your ladyship, this is part of the things that are also relevant to the inquiry. Your ladyship can draw her own conclusions based on what is contained.
No, but
in
Miss,
the paragraph.
yes,
Same way-
the issue that she's raising is that she didn't deal with this. Has got nothing to do with what she has with the address that she has just made. She's saying, but just could you argue? Just conclude, Mr. Pitlela, for the sake of progress, please.
As your ladyship pleases. Secondly, my lady, arising from what was said, that Ms. Ngube took patients several times. The point is, my lady, that patients were released in batches. I'm going to leave it to your ladyship to decide. With regard to the testimony of Mr. Nofile, my lady.
I thought when just a second. I'm sorry to be interrupting like this. The reason why you asked me to grant you the opportunity, you said you were going to refer the court to clarify certain issues, unless if I don't follow, and it seems that now you want to. I don't know. Is this a reply or what?
No,
Maybe I'm getting confused.
Yes, I'm gonna be very brief, my lady, and this is the point that I'm trying to get across. Your ladyship referred to the evidence, the affidavits of people that were not called to testify, and the point there was.
Is it not the point that you yourself made?
Indeed, my lady.
Yes.
Hence, I'm referring to Mr. Nofile in particular to say he was cross-examined, and we put forward a version that contradicts this version, and the court will then have to decide on which version to accept.
Okay,
which is
that one is made. Yes. Thank you.
Yes. Now, there's a proposition that your ladyship should accept those affidavits because those people will then be called to testify at a subsequent criminal trial. Should your ladyship find that there's, in our opinion, there's culpability or criminal whatever. But the difficulty with that, my lady, is it requires your ladyship to now consider evidence that has not been tested. And that is where we are saying the right to a fair trial needs to be counterbalanced in that regard. At the end
of the day, is that this forms part of the record, and in an inquest, we need not call each and every person according to all the affidavits that are there. So that evidence the court cannot ignore. It has to look at it. Continue.
Yes, and the last part, my lady, is with regard to the issue that we presented to court yesterday. The complaint, if I may phrase it as such, it is a complaint, my lady, and it is founded on the provisions of Section 24 of the Inquest Act, which provides, and I will read it to your ladyship.
Which?
The provisions of Section 24, my lady, 20 subsection 4.
Of the Inquest Act.
Of the Inquest Act. It says that any person who prejudices, influences, or anticipates the findings of an inquest commits a criminal offense, liable for, upon conviction, to a fine of 2,000 or 6 months imprisonment.
Yes.
Now, we are saying to this court, my lady, that the publication by Section 27, they coming out in public and saying this is what we are going to do and so on and so forth, it prejudices our client because, as we have indicated, my lady, our client was subject to witness protection because of this case. She had to go under witness protection because her life was being threatened. I see that also on the Daily Maverick website, they've carried a picture together with the picture of Dr. Manamela and also former MEC Esidimeni Inquest, for everybody to see who these people are that Section 27 is referring to. And that, my lady, is problematic and it's dangerous. And it puts our lives, our client's life at risk. And we are asking this court to protect our client. Unfortunately, my lady, it's something that emerged very late in the proceedings. We would have requested the court to act in terms of Section 10 of the Inquest Act to protect her identity, but that horse has bolted. And we are saying it's not sufficient, my lady, for Section 27 to adopt a stance of saying this matter is in the public domain, so we can speak about it, we can publish it on the website and so on. Heads of argument are for the benefit of the court. They are not for the benefit of the public. They are there simply to assist this court, not for people to use them as an opportunity to grandstand. And that is where we are, and we are putting forward this complaint on record to this honorable court and saying this court should investigate in terms of Section 24 and give us a finding in that regard. May it please
Yes.
you, my lady.
Yeah, but perhaps let me hear the last submissions and then I will hear further submissions in regard to the issue that Mr. Pitlela is raising.
Yes, your ladyship, please.
Thank you. Mr. Makani, in relation to what you wanted to submit in order to close your arguments.
Good afternoon, my lady.
Afternoon, Mr. Makani.
My lady, it's only one statement that we wish to clarify, and if I may, Advocate Hasila Adila SC said something like this, my lady.
Advocate Hasim.
Hasim, my apologies, my lady. Advocate Hasim, my lady. She says none of them demanded that there should be a halt. This, my lady, I submit with respect that this is not proper or this is not correct. I would wish to direct your ladyship to page 1106 on case lines.
Page?
1106.
Yes.
My lady, this is a letter addressed.
Can I quickly go to that page? 1106.
That is correct, my lady.
Yes.
My lady, this letter addresses the concerns and the options of the project to repeat each and every paragraph, but there is options that are given to the MEC or the former MEC, Mr. Dan Mashangu, and there's also recommendation from the project team, of which Dr. Manamela was part of. So, my lady, an impression that none of the project team members raised concern in the manner in which the implementation is to be done. It's wholly incorrect, my lady. And the letter, it speaks, or the writer thereof, who was the project leader, uses the word we. So in other words, it was not his letter, but of the project team.
Okay.
That is the issue that we want to clarify. And thank you, my lady, for giving us this opportunity to address this particular issue, my lady.
Thank you. Yes, can I hear submissions? Thank you, Mr. Makani. With regard to the issue that has been raised by Mr. Sibara, Mr. Pitlela. Does this issue that he's raising as a complaint?
May it please the court, my lady, I just would like to, Mr. Pitlela wasn't very audible, and I just want to ensure that he referred to section 24.
Section 20, subsection 4 of the Inquest Act.
My lady, unless there's a, I haven't got the latest copy, but if I have it, section 24 refers to the repeal of laws.
Is it 20, subsection 4?
Section 20.
See?
Section 20.
Oh, sorry, my lady. Section 20, subsection 4.
That's what he said, but I didn't look for it. I just listened to him.
My lady, I heard it.
What's your ladyship pleases? It's 20, subsection 4, my lady.
Am I correct? Because let me also look for it. Section 20, subsection 4.
Of offenses.
May it please the court, my lady.
But I don't have the latest one here. Yeah. 20, subsection 4.
May I quote for your ladyship's
yes,
convenience, my lady? Subsection 4 reads, any person who prejudices, influences, or anticipates the proceedings or findings at an inquest shall be guilty of an offence and liable on conviction to a fine not exceeding 2,000 rand or to imprisonment for a period not exceeding 6 months or to both such fine and such imprisonment.
okay.
My lady, with all due respect, insofar as it may be, as I'm in having audience now, I'm not sure that the complained of really falls squarely within the ambit of subsection 4 of section 20. And if I understood my learned friend's reply to this complaint when she addressed your ladyship, there was no intention to prejudice, influence, or anticipate the proceedings or findings of this honourable court, my lady. And if that was not the intention, my lady, I submit with respect, no offence has been committed, my lady. But I will leave it in the hands of your ladyship. May it please the court, my lady.
Thank you. Mr. Leet?
My lady, I think this is an aspect that should in any way be dealt with in the same manner as a contempt of court in terms of the Constitutional Court's judgment, in that if there is such a complaint, it must be, the complaint must be filed with the police, it must be investigated and be tried in a criminal court. It's not something that this court is supposed to deal with in any way.
Thank you. Mr. Hodes? So, okay.
My lady, all that I wanted to say as a point of clarification, my lady, is the letter that was referred to by Mr. McCarney is the letter that was attached to the email of 12 February 2016, which resulted in the 3-month extension. It's just a point of clarification, my lady.
Okay, yes, I saw that because I had to look for the letter. I thought you were addressing the court in relation to this specific issue. All right, thank you.
No.
Mr. Late, I see your hand is still up. Mr. Late, okay. Ms. Hasim?
Milady, there's a complaint of interference with this court, prejudicing the proceedings, and of a criminal offence. Second, The evidence leader suggests that it should be dealt with as contempt of court.
Yes.
My lady, we submit, first of all, that it is appropriate for this court to say something about both these allegations against Section 27. One, that there's a commission of a criminal offence, and two, that it's contempt of court. Those are very serious allegations to make. Now, firstly, the question of the publication of photographs in the Daily Maverick is something that should be taken up with the Daily Maverick, if that is the complaint. Second, and really this is the real issue, this is a public hearing. This hearing interest, and our courts have ruled on that. And I will find the citation for the court in a moment.
There's no need for that. We know for a fact that there have been rulings, but some of the matters should be heard this way, yes.
That they should be heard this way, but also that the media reporting on it is not in violation of anything. Media reports on cases all the time. Parties comment. There's no basis to say that this is a criminal offence. But there's a particular SCA decision, my lady, and that I just didn't have time in such short notice, because now we're being told for the first time, and in so-called reply, that we should be that we may be guilty of a criminal offence, that my clients may be guilty of a criminal offence. I think that is not something that this court should condone. And to say, for example, my lady, and this is the judgment I'm thinking about, it's where there was an issue about the media having access to court records, and the SCA ruled that it is permissible. And why? It's because it's in the interest of open justice, and that is what is taking place here. It can't be that because, and frankly, if Mr. Pitlela was concerned about his client's safety, it was his duty to ask that she testify in camera, or that whatever protection that needs to be in place should be in place. I'm surprised that I'm really quite surprised by these submissions, and we certainly won't let it lie. And we ask this court not to tolerate it.
Thank you.
Thank you, my lady.
Mr. Late, but before I go to Mr. Late, okay, continue.
There might be a misunderstanding by Mrs. Hussey. I didn't say that it must be dealt with as contempt of court. I said that it should be dealt with in the same way as it's contempt of court these days are dealt with, especially contempt of court in facie curiae. There's a judgment. I don't know exactly, but I'm certain your ladyship knows about the judgment. Is that it should be investigated like any crime, and it then should be heard as a normal criminal trial. Summary.
In other words, what you are tentatively saying, how I understood you, is that it is a matter that has to be reported to the police and be dealt with there, not for this court. Yes.
I don't agree with Mr. Pitlela. I said this is not something that this court should be dealing with. If they want to go ahead with a matter of the contravention of Section 24, then it must be reported to the police, investigated, and decided upon by the DPP.
Yes. Okay. And you still maintain that stance?
Yes, it's not. It's not. I didn't.
You
say that.
never said it's a criminal offence as in a way of agreeing with Mr. Pitlela.
No, definitely not. No.
Yes,
No,
I think that's how she understood you. Yeah. All right.
As a conclusion.
Yes, Mr. Pitlela.
As your leadership pleases, my lady, let me clarify one thing here. I see people are letting the emotions get ahead of them. I am saying this act of publishing on the media and saying this is what we're going to do and so on fits, to me, in my interpretation, it fits within what is described in section 20 subsection 4.
Oh, okay.
Now, did I say section 27 were guilty or anything of that nature? I'm not, why would I say that? I'm not a court. A finding of this court. So them coming in 7 is guilty of this or guilty of that, that is not for me to determine.
Okay.
I've raised a complaint. I've articulated that complaint. I've given court the circumstances why we feel that this thing is a serious violation of our client's rights. And I've given a court the empowering provision, which is section 20 subsection 4.
Okay.
So I don't appreciate this threat of being this and this and that, my lady. It's
okay, that's fine.
It's uncalled for.
Thank you so much. I see you can just lower your hand. The last hand now it will be from Ms. Hasim so that we can close the proceedings.
My lady, but first I'd just like to recognize Mr. Late's clarification, and I thank him for that. I certainly did misunderstand his submission. There's no threats that I'm making. The threats are being made by Mr. Pitlela. The issue of a criminal offence didn't come out of our mouth. It came out of his mouth. The reference to the case that I spoke of earlier, my lady, if I could give you the citation. It's Cape Town City versus the South African National Roads Authority and others. And it's 2015, Volume 3, SA 386. And it's a judgment of the Supreme Court of Appeal. And it was a case in which the court specifically had regard to, considered the issue of court records in particular being made public, and where the court took the position and made found and held that openness and not secrecy was the default position under the Constitution, and that right to open justice includes the right of access to court records. And in my view, and I submit to this court records include heads of argument.
Okay. Thank you.
Thank you, my lady.
Thank you. Yeah. There is a complaint that has been raised now by Mr. Pitlela with regard to the publication, alleged publication that came out in Daily Marivic. The information having come from Section 27. Well, it's not clear as to actually what this meant, but Mr. Pitlela referred to the court to Section 20, subsection 4 of the Inquest Act. That was read into the record by Mr. Pinar, and he wants the court to determine the issue. Having had the submissions from both sides, Mr. Pitlela and the Ms. Hasim and the others, I don't think this is something for this court, and I cannot find any prejudice or influence to the proceedings that the court is busy with. If Mr. Pitlela thinks that this is a matter for serious concern, I believe that he has a right or to advise his client to report the matter to the police so that it can be investigated and a charge can be laid in this regard against whoever is responsible for the utterances that Mr. Pitlela has just referred to. Yeah, in relation to
that's your ladyship.
The matter at hand, I want to thank every one of you who have made their submissions to this inquest court. I believe and trust that they will assist this court to make proper findings. The proceedings for today and the hearing of the evidence in this matter have now been concluded. What is left is for the court to make its own findings and recommendations. Thank you so much.
As the court pleases, my lady.
As the court pleases.
As your ladyship pleases.
My lady.
As the
As the court pleases, my lady.
May it please the court, my lady.
As the court pleases.
As court, right?
As the court pleases, my lady.